Welcome to Straightforward Estate Planning with Pedrani Law.
Hey everybody, welcome back to an all-new episode of Straightforward Estate Planning with Pedrani Law. I'm your host, Mike Leon. Keith here is the founder of Pedrani Law, and he brings both a legal and business background to helping families plan ahead, providing clear, practical guidance in estate planning, probate, and Medicaid planning so you can protect your assets, secure your legacy, and have peace of mind for the future. And in today's episode, we're going to be focusing on comparing probate and trust. We'll look at what they are, how they differ, and what families should consider when deciding which approach works best. So Keith, good to see you as always. First off, let's start with the explaining part of this. What is probate and when does it become necessary after someone's death?
Thanks for having me, Mike. And probate, from a high-level view, is the process of settling someone's estate after they pass away. So any assets that you own individually at the time of your death would be a part of your estate. To make it a little bit more concrete, in New Jersey or New York, your will would be probated in the county that you passed away in. So, we're in Bergen County right now. So the surrogates court in Hackensack would handle that. Up in New York, same thing, just the surrogate court in the county where you passed away. Probate's necessary if you have a last will and testament. Probate is also necessary if you pass away without a will. If you die intestate, your estate still has to be settled. It's just governed by intestate succession at that point.
So Keith, now explain what a trust part of this is. How is that different than going through probate?
If you have assets that you place in a trust, that's going to take them outside of the probate estate because you no longer own them in your individual capacity. You own them as trustee for your trust. So if it was the Mike Leon revocable trust and you moved your primary residence into the trust, it would no longer be owned by you individually. So that takes it out of your probate estate and the asset then passes along pursuant to the trust instructions. It is still counted as part of your taxable estate, assuming that trust was revocable. If it was in an irrevocable trust, then it would not be countable for your taxable estate. But there's interplay between the two. It's typical that even if you have a trust in place, there are still other assets that are not in the name of the trust at the time of your death that do have to go through the probate process.
And Keith, why do so many families try to avoid probate if it's possible?
Probate can be expensive. It can be time consuming. It's handled by, like I said earlier, it's handled by the surrogate court in the county where you pass away. I can speak for Bergen and Orange and say that both have great reputations as being very efficient. So probate might not take as long there. Can't really speak outside of those counties, but either way, even the best surrogate court is still running on a court schedule. It has other cases. You're going to be waiting. You're going to be waiting if you want to hire an attorney to deal with the paperwork and the process involved. You're going to be paying that attorney usually by the hour. And it can take a long time to get through probating an estate, even in the best of scenarios. And in the worst case, you could have conflict that can drag probate on for years, really. So a trust is more clear. A trust is more instantaneous. The transfer of assets through a trust is not going to become public record the same way a last will and testament will. But it is a lot more upfront. So it's certainly has its advantages, but it is a lot more work by you up front.
So Keith, it's expensive. It could take a long time and the court is deciding. Are there any situations where probate might be necessary or even useful?
There are plenty of situations where probate is necessary, and that's any asset that you don't put into a trust, your heirs are going to need to go through probate, even if it is just to use the probate process to get that asset into the trust. You still need the court's intervention to do so. where it's useful for that aspect, and it's also useful for, of course, settling estates where you only had a last will and testament. Uh, there wasn't a living trust that was created. So it's definitely it's needed. There's no question about that. But it just can take a lot more time than if you just funded a trust and had assets passed by the instructions of the trust. So, but to carry out the wishes of your last will and testament, if that's the only estate planning document you had in place, or a pour over will, like I said, just to get the assets into the trust, it's a necessary process, and it's not. Uh, like I said, it can take a while. It can be somewhat complex, uh, but it's not overly daunting. With the right guidance, it doesn't have to be, a daunting and overly expensive process.
Can you kind of drill a little bit more into the trust aspect of this in terms of how it helps families save time, money, or even stress compared to probate? Do you have any examples that you can share of how a trust helped in those areas?
Sure. So the big one is usually the primary residence. That's usually the largest asset for most people. So to help your heirs, you can put your primary residence and your other assets into a revocable trust while you're living. So that's going to require you having the trust prepared, or preparing the trust, preparing and recording a transfer deed, ideally having a pour over will to work with that trust to use the probate process to get any assets that weren't titled in the name of the trust during your life into the trust after death. And that's going to save your heirs from having to go through the probate process to sell or otherwise pass on your house. So if you think about the two different situations that you could leave, so let's say that you prepare a revocable trust and you fund it properly, and then you pass away. The properly funded revocable trust is going to have hopefully the house, hopefully any other major assets. Let's say you have a vacation home that's out of state, but it's properly titled in the name of the trust. That prevents your heirs from having to open ancillary probate in other states because it's already titled in the name of the trust. And that piece of real estate and the other assets that are in the trust pass pursuant to your trust instructions right away. Whereas with the last will and testament, you have to go through the county, you have to fill out the questionnaire, to open the file with the surrogate's court, make your notifications, go through the process of getting the letters issued. And with each step, there's time involved. So the trust can really save a lot of time, can save the cost associated with going through probate. And really it's more of an investment up front in preparing the trust and funding the trust. It's more of an outlay initially. It's more of a time commitment initially, but you are going to your heirs will realize that savings in probate.
I mentioned at the beginning in the intro about New Jersey and New York. I would love for you to kind of explain the differences between the probate process, or even how trusts are handled in New Jersey versus compared to New York.
So the process is really not all that different. So the trust is going to be essentially the same in each state. If you put the assets in the name of the trust, you're going to take them out of your probate estate. That's true in both New York and New Jersey. Probate in New York versus New Jersey, there are some nuances along the way that are slightly different, but the process is basically the same. The idea is to satisfy creditors, distribute assets, and to validate any last will and testament that was left. So you have very similar processes that are occurring in each state. The estate taxes is where you're going to see a difference between New York and New Jersey. New Jersey, if you're going to Class A beneficiaries, has pretty much eliminated the estate tax at the state level. Still exists for non-Class A beneficiaries, so non-lineal blood descendants. So if you are planning to pass to any beneficiaries that don't meet Class A, then you would do some planning as to how best to avoid the estate tax if that's possible in New Jersey. In New York, you are still having some tax considerations in planning, but that's the main difference you're going to see. The probate process is really very similar.
A second ago, you mentioned about the expenses and time frame part of this with probate, but compare that to the initial cost of establishing a trust. How do they compare?
The cost of establishing a trust and funding the trust is really quite minimal compared to what you might spend in probate. Probate, you have to keep in mind that it's almost always going to be at an hourly rate or some percentage of the estate. In either event, that's going to cost more in most cases than document preparation while you're living. And you can either have an attorney like myself fund the trust, or you can have the trust prepared and you can take over the funding aspect. I prefer with my clients that, at least for the major assets, that we're involved in funding the trust. But sensitive to the fact that adds cost to it. But generally speaking, the cost to prepare and fund a trust is going to be significantly less than the money that would be spent in probate dealing with those assets.
So, Keith, we've kind of touched on both probate and trust here at a high level as we wrap. When a family right now that's potentially listening to this, they're deciding between the two, between probate and trust, what would you advise them the best way to determine which option is right for them?
Well, the first distinction to draw is that they're not mutually exclusive. So you can have a trust and the estate will still need to go through probate on some level. But what you're doing with the trust is taking the major assets out of the probate estate. So you're going to minimize the amount of the estate that goes through probate, but it is very common to have a trust, also have the pour over will, use the probate process and the pour over will to get assets into the trust that were not titled in the trust during the lifetime. So you're not really choosing between the two. What you're choosing to do by drafting and funding a trust is take the major assets out of probate and avoid probate for those assets. So I just want to be clear that it's not mutually exclusive, and just by drafting and funding a trust doesn't mean that your estate is going to avoid probate entirely. The idea is just to minimize the amount of assets that have to go through probate.
Keith, thank you for the time and insights on this. As always, we truly appreciate it.
Well, thanks for having me, Mike. Much appreciated.
And thank you to everybody out there listening to another installment of Straightforward Estate Planning with Pedrani Law. If you'd like help right now deciding whether probate or trust makes the most sense for your family, remember, they're not mutually exclusive, visit PedraniLaw.com to schedule a consultation with Keith and the team. And don't forget to like, subscribe, leave us a review and comment, or share this episode with someone who needs to hear it. As always, I'm Mike Leon. We'll see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.